you very much. We are Tbilisi State University Faculty of Law is pleased and honored to introduce Big Schachter, one of the distinguished practitioners from the United States in the field of ADR and especially in mediation. Vic has over 50 years of 50 years of experience in litigation.
I started when I was 5 years old.
And in ADR, and he has worked on dispute resolution design programs throughout the US for companies like Cisco Systems, Facebook, Apple. And Vic is a great friend of our faculty and the whole Georgia, and fourth visit when Vic helps us and supports us in setting up ADR programs and mediation programs, especially. And for this time, we are lucky to have Vic with his friends, Jennifer Brandt and David Weiss, who are also practitioners in the field of ADR and who work for Vic's Foundation as mediation ambassadors. Today, Vic will speak with us about mediation challenges, about how they begin in US, what are the challenges we have, what are the risks we have now, and how can we overcome all these impediments that are now interfering and not letting us to develop and to enforce mediation programs in our country. Vic, thank you very much.
A pleasure.
For visiting. Please listen here.
Great, thank you. So, thank you very much for the invitation to come and speak with you. We always enjoy speaking with students, faculty, and professionals in this area, particularly Jennifer and David and I. We have just finished a trip to Bulgaria, a country that you are familiar with, and tomorrow night we head out for Croatia, where we're returning as well. This is my third trip to Georgia, and I want to tell you, before I came here, I weighed about 150 pounds, and now that I'm leaving, I'm sure I'm pushing 200 pounds because of the wonderful food that you have here. Tonight we have yet another large dinner. I think they're not going to let us on the plane tomorrow night with all the dumplings and the wonderful foods that are here. Georgi has spoiled us terribly. But we're really delighted to have the opportunity to speak with you. And let me tell you a little bit what we'd like to do so that you understand what we're expecting of you. I'm going to comment and give you a little history of kind of how mediation has developed in the United States, not because we want you to feel that's the way it needs to be done, but rather give you an example of the impact mediation has had on our entire judicial system and the impact that mediation has had on the way we practice law. It's been enormous, and I've seen this over my 50 years dramatically change in just the last 15 years. What we do as lawyers, how we're paid, what our clients expect from us. So I want to provide that overview to you, and then Jennifer and David are going to talk a little bit from their perspective. Jennifer's going to talk from the perspective of a very accomplished mediator with full-time practice who's been very involved in international mediation initiatives. David is going to talk about his academic perspective on this as a professor of law, as well as his involvement in many international mediation activities. And we hope from this brief overview that you will get a good feel of what kind of the trends are, because you are the future of what's going to happen here in Georgia. And I will tell you, the longer I work in countries like Bulgaria and Croatia and Georgia, the more I feel, and I've mentioned this to Georgi, you are really what's going to make the difference here. We have a lot of challenges with long-time lawyers in your countries. And these lawyers are not very open to the concept of mediation. You know, I see some of you are smiling already. As you'll hear us say repeatedly, many of the lawyers in each of these countries, as we did in the United States, think ADR, alternative dispute resolution, they think it means awful diminution of revenue. That they're going to lose their income, they're going to lose their jobs, and they're going to lose their work in the courtroom, and therefore are oftentimes very, very hostile. Also, uniquely in your countries, much because of the history of civil war and disturbances and evolution after the Russian involvement, and now as emerging democracies that are really building a wonderful frame of reference. A lot of work ahead, but a wonderful frame of reference of building the kind of society that provides freedom and economic independence. Clearly, it's very, very important to see how all this fits into the economic picture of what you're building, and you're strengthening the European Union, you're strengthening the world, and then the global community. And all of this is something that's really important to us. I found that many of the lawyers we speak to, they ask the first question, the second question. First question is, how do we make money? How do we make money if we're doing mediation? And I'll talk just a moment about that, for a few moments about that in my presentation. The next question is, why do I want to make peace with my enemies? And for us, it's such a strange thing in the United States to hear people say that. Why do I want to make peace with my enemies? Because 200 years of democracy, the first question we would ask is, why wouldn't I want to make peace with my enemies? And this is a really totally different mindset and a totally different orientation. And you are the future of bringing a flexible and open mind to this process in the way you practice law, in the way you conduct business, and the way you build your profession. And if you miss riding that wave, you will not be part of this international community, because it is moving so fast as the world, as we say, is flattening. There is so much going on internationally. You need to understand how mediation can work for you as a professional, as a business person, as a legal advisor, to be part of this community. And if you're not, you're going to end up with a very narrow view of what your potential will be in the world overall. So let me ask the question, how many of you here are students? Okay. And faculty? Do we have any faculty here at all? One or two of you? Okay. Okay, good. So I'm going to focus my comments primarily to you as the student community, because I understood that was going to be a larger community, and I welcome, of course, any input of faculty and leaders and executives here in your program. And I must say, I'm so impressed with what you have here in terms of your ADR Center. This is the second time I've been at the center, and what all of you are doing has just been terrific to build a meaningful curriculum, starting to build a meaningful curriculum and see it emerge to support this important area. Let me just give you a little perspective. In the United States, 35 years or so ago, we had, like you have here in Georgia, a large backlog of cases. And it took years to get a case to trial and to get a result. Not as large in other places in the world. The countries that I've been involved in, with Jennifer, particularly in India, the backlog there is 32 million cases. Population slightly larger than you have here, of 1 billion people, okay? And if they can do it there, you can do it here for sure, to set up a program. And they have many of these programs running very successfully now. And Jennifer and I have also worked in Brazil, which I was surprised to find out in our work in Rio and Brasilia and Sao Paulo and so forth. They have 101 million cases in backlog. That's a case for every 2 people. They only have 250 million people. They're worse in backlog than is India. So when I look back at the problems we had in the United States some years ago, it wasn't as large as these countries, but it took a long time to get cases to trial. And at that time, the Chief Justice of the court, our federal court in California, where I came from, came to a group of our lawyers and said, look, you really got to help us. We need you to vote. We're going to train you to do mediation, and we want you to get some of these backlog cases, and we want to get them through the system. We want to remove the backlog so we can get greater access to justice for many of the people that are there. And what do you think we said? We called together 25 of so-called prominent lawyers in San Francisco. And he said, we want you to volunteer your services to settle cases that otherwise you take to trial and make money. We sat there and said, you got to be kidding me. We'll say, yes, we'll do it, but we're not going to really support something like this. It's cutting away at our own work, and why would we want to do it? And they trained us, went to 40 hours of training. After that, we had to go in and actually observe mediations for, in that case, it was 10 mediations. And then when we did our first mediations, we had to be coached, and then we started to do them. And I, like many others in California, other states throughout the United States, and particularly through the federal court system, we found we love this work. It's a wonderful feeling to win a trial, whether it's a jury trial or a bench trial. But I got to tell you, it's something else when you can use your own skills and bring two feuding parties together and resolve a matter in a matter of an hours or a day or a couple of days that otherwise would drag through the courts. Now, in the beginning of this process, about 35% of those cases that were filed went to trial. After mediation, mandatory mediation we had there, mediation, and we have something called early neutral evaluation. You probably are not too familiar with that concept. It's an evaluative process. It's like mediation, but a different goal. It kind of makes a judgment about the case. It's non-binding to the parties. That's another technique that's used. Let's focus on mediation for today. Now, what would you think the percentage is of cases? We had 35% 30 years ago. What do you think it is? 20%? 25%? 15%? 10%? 5%? No. It's less than 3% of the cases. Do you know the impact that has had on our court system? First of all, our judges have a life now, number one. Number two, they can try the cases that need to be tried, and there are cases that need to be tried. And third, and most importantly of all, it gives access to people to real justice when they need a judge. But all those other cases where you can use mediation, bring people together so they can voluntarily reach a resolution that's acceptable to them instead of some court-imposed mandatory judgment or an arbitrator telling them who's right and wrong. They participate in the process, and many of you know this from the courses that you've taken and the exposure that you've had. And it's become so popular that we now find people aren't going to court. In fact, even before they sue, they call up, if they know who the lawyer is on the other side, they call up and say, let's go to mediation. Now, I said this to Georgian lawyers, and you know what they said to me? What do you think they said to me? When I said, you call your client and tell your client go to mediation. What do you think your lawyers said, aside from the fact they're going to lose money? That if you call the other side and you say, do you want to mediate this dispute, what do you think they thought that meant to the other side? Betrayal? Okay, that's one of the client. And what else? That you had a weakness in your position and you're afraid. And that's exactly the opposite of the way it operates in the United States and many other countries. All the time, I call the other side. I was on the defense side. On the plaintiff side, the plaintiffs call, and I know they'll call me on the phone and say, Vic, do you want to take this case to mediation? And I know when they do that they want to try and resolve the dispute. I don't think that they believe their case is weak. And in fact, quite to the contrary, I look forward to finding out what they think the strength of the case is, so I can assess for my client whether they should litigate the case or try and reach a resolution. The point being that the vast majority of these cases get resolved that way. And in my practice, there's some tiny companies I've represented. You may have heard of them. Facebook, Cisco, a couple of those companies you may be quite familiar with. And in the Google is another one you might know something about. These are companies now that look for the opportunity to resolve these matters through mediation. So what is kind of the bottom line that I'm trying to share with you here? Your future, as your business people, as your clients, as the people that you are going to interface with, they're going to get to understand this. It's not going to come tomorrow. It's probably not going to come in the next year for sure. But it is going to come over the years as lawyers learn to use this. And it's going to become very, very effective. Now, Before I kind of turn it over to my colleagues, and then we're going to have an open question and answer period for at least a few minutes with you, if you're interested in doing that. The lawyer's role. I want to just talk a little about the lawyer's role. So what does a lawyer do in a mediation? Do they have any role? And is there any way they can earn any compensation? What does a lawyer do in court, right? They investigate their client's case, right? They study the case, they learn what the facts are. Then what do they do next? They prepare the client. They look at the evidence. They prepare the evidence. They write briefs to the court about the evidence. They file motions. And then ultimately, if it doesn't settle, they go to court, right? And they represent their client in court. And they try to win the case. And they put together a strategy, again, working with the client. Well, what do you do in a mediation? What does a lawyer do in mediation? Do you think it's much different? The answer is no. When I represent a client in a mediation, now I'm not the mediator, which I do on the side now, but during litigation years, when I'm representing a client, what do? The first thing I do is I investigate the facts. I want to know what the facts are. I have to analyze the law to assess what the strength of the case is. I'm paid to do that. If we choose to have a mediator, what about the mediator? What do you do with the mediator? In our system, we write briefs, fairly extensive briefs, which we discuss with the mediator, we present to the mediator before the session is held. We write a brief on the law, we write a brief on the facts, and we get ourselves prepared to go in and to convince, to provide to the mediator the strongest facts and law that we can, so that mediator can get from the other side the best possible settlement for the client. We're paid for that as well too. And then what happens when we get to the mediation itself? Does the lawyer participate? Absolutely. The lawyer is a full participant in presenting the arguments and convincing the mediator what the proposal should be, if there is a settlement, and writing up the settlement, and seeing that the settlement is enforced properly in the courts so that it has binding impact and effect. All of that, I bill at the same rate for that work that I would if I was in court litigating the case. And the benefit of that is that when it's done, if that client's happy, I get referrals of other matters, other corporations, other clients who said, these guys understand what my business needs are and help me to get to a resolution, and not in there just to grind out all the hours and the cost of litigation and the cost of appeals. And then I end up with something that is final and it's binding. The last thing I want to mention is the unique opportunity you have to design in the mediation process, to design the kind of solution you want. I want to give you one illustration which I think demonstrates it really, really well. I had 2 chief executive officers in Silicon Valley. That's where I'm from. You all know where Silicon Valley is, right? You've seen the James Bond movie, right, with the Silicon Valley blowing up and all that business. It's absolutely the hotbed of entrepreneurial enterprise. So I had these 2 CEOs. They hate each other's guts. I mean, they really, as I like to say it, if you put a gun next to the CEO, each one of them, and it were lawful, they gladly would have shot one another right then and there. They accused each other of stealing trade secrets, of stealing their key executives, of doing all kinds of terrible, what we call unfair business competition practices. Now, they were prepared and they had the wealth to go litigate that case endlessly for probably 9 or 10 years with all the appeals. And they wanted to beat up the other side something really terrible because they felt they were being victimized by all these unfair business practices. And what we did in that mediation is I put together a proposal in which the 2 CEOs agreed, instead of fighting all these years, they agreed to create a new joint enterprise when they came out of the mediation, a new company in which they both worked together to build that company. And today, that company is stronger and making more money than each of their separate companies. No judge could ever provide that. No judge in a family dispute allows people involved in a family dispute allows them to use an apology. The power of an apology is an incredibly powerful tool in highly emotional disputes. And there are all kinds of tools that are available to a mediator to make all of this work. So, enough by way of an introduction. I want to give you a little context and some of the approaches that we use in this area, just to emphasize how important it is in the dispute resolution process, the economics of it, the practicality of it, and the ability of it to move it forward. And the result is that you, if you grasp this, if you use this, your society will build a credibility and effectiveness and a profile in the world community that will really make a difference. And you're going to make a great deal of money in the process. So, with that, let me turn it over to Jennifer and then to David to share with you some of their perspectives that are a little different from mine, and then we'll open up to your questions. Jennifer?
Thank you. It's a pleasure to be here. It's an honor to be with all of you, young students at the beginning of your future and career. I've been a lawyer for many years, and I have been doing mediation for many, many years. I find mediation to be the best method of dispute resolution. It's better than going to trial. It's better than arbitration because it is a system that preserves relationships. It preserves a relationship in family law, family cases, divorce, children, family businesses, commercial contracts between parties, estates, inheritance laws between brothers and sisters after their parents have gone. And it's just an excellent way. It's also a system where you can plan and create your own solutions. You can do things, as Vic has just said, that a court cannot do. The other thing about going to trial is you don't know what the outcome is going to be. There are laws, but it is always interpreted by the judge. You don't know if you're going to get a judge who's favorable to your client or who is not favorable to your client. Maybe they had a fight with their husband that morning and they're in a bad mood. So maybe they have a child like your child and they're not going to be sympathetic. So it takes control and it brings it back to the party to have a way to do it. Now, in the state where I am from is New Jersey, which is right next to New York. And many years ago, we started a mandatory mediation program, a required program, where certain kinds of cases had to go to mediation before you could ever go to trial. And this was started in family cases where there was divorce, children were involved, because they figured this is actually the area of law that is the worst kind of law that should go to litigation. Because eventually, the parties will have to learn how to talk to each other. Because if you have children, you will always have to have a relationship because of the benefit to the children. So our program also, like Vic's case in California, less than 2% of all cases go to trial. So we have many different steps along the way to encourage settlement of these cases. Also, mediation is a way not only to save money for the parties, it saves the court time and money, it saves aggravation, it is more friendly and amicable, but it also basically provides access to justice. Now, access to justice is a basic human right. We have a saying that justice delayed is justice denied. So people have to wait years. In some of the countries we've gone to, people could wait 10, 20, 30 years to go to trial and have appeals. Children inherit their cases from their fathers. We met an attorney in Brazil who said when he was a young man, he had a certain case, and 30 years later, he is still dealing with that case at a different level. The other thing I want to say is, it has been a pleasure to be in Georgia. I have found the people to be amazingly warm and hospitable. And we've had the pleasure to have dinner at the homes of some very good friends, including our wonderful colleague right here. And there's a system of toasts and toastmasters. And the first toast...
And with a little liquor that comes with that too.
You have to finish it. Well, of course, we rise to the occasion, as they say. The first toast is for peace. To me, mediators are peacemakers. And making peace makes a better world, makes for a better life, and it is the future, as everyone says. So, thank you.
Before I turn it over to David, I want to tell you, we learned last night that one of Georgie's students who's been involved with the judiciary for many years and is leading the judiciary, invited us to his home. And he said, you have to have just a little a little glass, a little
A shot.
a shot of what was an unbelievable shot of liquor. And the glass you have in Georgia, it's like this large. And in the U.S. we have one that's this tiny. And apparently the tradition is, and he told me we couldn't stay for the rest of the dinner, if you don't drink it all at once, you can't just sip it. There's another glass if you sip it. So we were very happy about 5 minutes into that dinner. And I do remember the shot, but not much more. David.
Thank you, Larry. So going last always is can be somewhat trying when you hear from esteemed colleagues that sort of used up some of the same things that I was going to talk about, but in different terms. I'm not going to bore you as a professor. I'm not going to bore you in theory. I think you got enough theory in class. So I'm going to talk from a practical perspective. And to do that, let me sort of just give you a short understanding of where I come from. So in my long professional career, I am a lawyer by trade, an American trained lawyer, but I was on Wall Street for many, many years with my own company. So I had the function of being what we call in-house counsel and head of capital markets and sitting on the board of directors of companies, which I've sold. And then when that part of my life ended, and yes, I do look young, but not that young. I'm probably the oldest in this room, like other than Uncle Vic over here.
Right, Grandpa.
Yeah. I decided to go to the Sorbonne at Le Droit, and I got exposed to this bug that we all have called ADR, which in the United States we are now calling appropriate dispute resolution. You may know it more as alternative dispute resolution. I come from the business perspective, so I'm going to give you some thoughts as takeaways for those in this room that are interested in the international business community, or also as lawyers representing clients here in Georgia, as Georgia continues to expand and grow. In fact, one of the fascinating observations I've had on my first time here is that I think Georgia is uniquely positioned. It is one of the jewels, we'll say, in this region, because I think it could become the Switzerland of this area. Its cultural characteristics are very similar in style to most of Western Europe and also to the United States. And I think as things develop, and the people in this room here, you, who are the future leaders of this country, play an integral and important role in that. And I think mediation acts as a bridge for that process. So let me just sort of give some thoughts about how you can do that. First of all, how many of you have participated in international competitions such as the ICC competition, or at least heard of the ICC competition, because I know your school participates in it, or which ELSA sponsors, which is the CBRC competition in Vienna. Is anyone familiar with it here in this room? Okay, I'm seeing one hand over there. So you should really embrace the thought of getting involved in competitions that take place around the world, because it's a way not only to build collaboration amongst your own teammates, but it will expose you to an internationalization of other teams and other cultures so that you can bring those experiences back home with you, and they will last forever, especially within the business context, where you will have multiple different types of elements that are important for you to understand as you develop your skills as young lawyers and future leaders in this country. The second thing I would suggest while you are students is to do some research and to publish or to work with your professors on learning. In fact, what I'm really, really excited to see is this alternative dispute resolution book. This is phenomenal. I mean, you have well-established programs in the United States, and they don't have journals like this. So you should really take advantage of doing publications and research so that you become more familiar with areas that are of interest to you, especially in the business field. In terms of what's happening out there, there have been several things that I think are important that you should be aware of. We just completed what was called the Global Panel Conference Series, which took place in over 37 cities internationally from all over the world. Thousands of business people participated in these conferences, academics, providers of mediation and arbitration services. And one of the biggest takeaways from that, including research that I did for over 2 years, is now being presented as I speak before UNCITRAL at the United Nations, and part of what has been explored for enforcement of cross-border mediation settlement agreements, is how users, the business community, feels about the use of mediation. And what's important and the takeaway from all of these events and research is that the business community not only is interested in using mediation, they need to use mediation as part of an overall strategy to promote their businesses and to invest their businesses around the world. Now, why is that important? Because what it says is that although arbitration and other forms of litigation in domestic processes are important, mediation is a business tool. It's not just for lawyers, but it's also for the business decision makers, because it acts as two very important elements. From a risk perspective, it is what we call risk sharing. So it allows parties to collaborate using, for example, mediation, which is actually a theory that I was published on in Europe last year called economic efficiency mediation. So even before you get to the level of conflict, and it allows parties, with the help of a third-party neutral, to be able to continuously have dialogue as changes in the environment, meaning their businesses, their business holder interests, such as you will find in family businesses, you will find in trade agreements, you will find in the general corporate governance of running a business. So having these sorts of models, these innovative models, will then stem conflict, and it's what we call the long shadow of a contract. Because contracts, as you know, what happens is you have a beginning and you may have an end. And in between is where you will then at some point in the process wind up at some point with conflict. So this is what we refer to as the long shadow of the contract. Mediation can play a really important role in the prism of that process. Within the concept of the conflict stage, which many of you have studied and understand completely in this room, is that mediation plays an optimization process. So from one perspective, we have maximizing value through the risk prism. And then from the conflict level, which Vic actually gave a great illustration, you have maximizing solution value. And the solution value that Vic demonstrated is what his example of that joint venture that came out of the conflict. Well, think about if you were sitting there litigating a case where the two parties actually do a joint venture agreement. No, there would be no fair opportunity to do that because it's a winner-take-all scenario. And in that winner-takes-all scenario, Jennifer made a very important comment, and that's about reputation, or what we refer to in the business activity as enterprise value. So a great example is that if you had a company or two companies filing lawsuits against one another, and all of this reputational information is out there in the public foray, what happens no matter who wins the litigation? Everyone loses. Because the reputation is going to be hurt at some level, whether it's with the stockholders, whether it's with the consumers, whether it's in the culture of how you run the business, whether it's in the depletion of capital resources. And you were at the epicenter of all this. As the professional legal advisors, you are in the driver's seat. So part of your job is to advise your clients and provide that value as to how you can best enable them to stem the process of minimizing their solutions and maximizing those solutions. And mediation is part and parcel of that. And that's why the user community is adopting and embracing this much more so. Now, do we have gaps in the system? Absolutely. One of them is what we call certainty. So how do you create certainty? Certainty is going to be done through policy. So again, there are opportunities as the next future generation of leaders here in this country to help in engaging and being part of those discussions, not just here, but outside of Georgia, and how you can help in a cross-border sense. Because ultimately, in order to promote trade and commerce, you have to have international shared understanding through treaties, such as the New York Convention, which allows certainty, which allows a small to medium-sized business, not just necessarily a General Electric, not necessarily a Boeing, They need this as well, but just think of a family business, a tire business, a candy business that wants to sell their goods either here, or you want to sell them in Germany, or you want to sell them in Brazil, or you want to sell them in the United States. Ultimately, if you go back again to that long shadow concept of the contract, if you are the owner of that business, one of the things you face is the risk of a dispute. And you're not going to necessarily have the funds or the resources to be able to go to that country and have to fight a litigation case against your counterparty that you had a relationship with. So what is a better way so that you cannot take a position where you don't invest, where you don't expand, but rather you do the transaction? Mediation can play a role right from the beginning of the transaction. And that's an important takeaway I want to leave you with, because I know we all focus on this from the opposite paradigm of this prism, which is mediation only serving when it's already in conflict. But think about this, mediation can serve even before conflict.
Good, thank you very much. So what I'd like to do is open this up to your questions. I do want to build on what David said, and if any of you are interested, we may be able to get you some copies of this, but the consequence of what David's been talking about together with Jennifer is that in almost every commercial contract now that we see in the States, there are clauses. At the time everybody is loving one another, there are clauses that basically say, in the event of a dispute, we agree that that dispute will be taken to mediation in order to resolve any conflict. And if that doesn't work, we will then go to arbitration. It's what we call mead arbitration. It's a combination of the two. And that is a great opportunity to minimize the risk and come up with a conflict procedure when everybody's feeling good about one another, and that saves all the time that results from breach of contract claims and extended litigation and all that goes with that. So we see this now in all kinds of transactions that really work very, very well. And I just want to give that practical example to build excuse me, on what David is talking about. So, with that in mind, let's open up to your questions and see if you have anything that you'd like to ask us. Please don't be shy. Please feel free to speak up. And we know your English is a lot better than you admit to. Don't be reluctant at all to raise any questions that you might have. Any questions? Silence. Yes, thank you for breaking the ice.
The main skill for a mediator which need in the process of mediation is, I think, it's a sense of humor. Is it right or no?
Mm-hmm. So the question for those that you may not have heard in the back is, one of the main skills is a sense of humor. And is that right? Does that play at all in a mediation? So picture the parties are at each other's throats, right? And everybody's all tense, and you're reaching an impasse in which nothing is moving along.
It's like an injection.
Is there any value for humor in a situation like that, Jennifer and David?
Absolutely.
No, I think no.
Yeah.
Use it in an illustration on a good one.
Okay, David, you're elected.
So I think illustrations are the best. Yes, the answer is there is no. One of the nice things about mediation is that there is no right or wrong when it comes to mediation's way of delivering the techniques that you learn in terms of how to do a mediation. We all have what we call our own individual mediation styles. So some of us will not have the same quick-wit humor that other mediators have, and that doesn't mean the other mediator's not a bad mediator. But how it can be delivered and the appropriate time is also important. So what you have to be able to do is you have to be able to read, and Vic pointed this out, as to when you think the temperament in the room is at a level that either requires some sort of disengagement, and humor can play a role in that disengagement. There are other ways that you know, taking a coffee break, having a caucus, right? But one of the things, if you have a rhythm and you're in the same room and you're in the maybe even the beginning of the process where opening statements are being presented by both parties after the mediators presented their own opening statement, and it's already just begun, and you have this sort of tension that's so heightened that you haven't even gotten to anywhere in the process that would be substantial in nature. I think if you can have some humor, if you can break the ice, if you can humanize and personalize the process a little bit for both sides through your own lenses, is a very important thing to do. And I've done it many, many times over as a mediator.
And it gives an element of humanity to the process, which is really important. I'm not as creative as the humor of some of my other colleagues who are just terrific. They've got some standard lines that they use when everybody's kind of ready to choke one another, but it really makes a big difference to take that pressure down. It really does.
And I'll just add
Please,
briefly,
Jim.
I use humor because that's my style, and I think part of being a good mediator is also to use your own personal skills. There are certain techniques every mediator needs, good listening skills and patience, and having an empathy for the parties and building trust, and all of those skills are very important. But you also have to be who you are in the process. And if you have that sense of humor and you feel comfortable with people, I find it eases the relationship. It takes some of that intensity and the tension away. But I think it is an important skill. But if you don't feel comfortable, and as Vic says, he just doesn't love it, even though he is quite funny, in that situation, then don't use it, because trying to use humor when it doesn't suit who you are may be more often.
Yes, it depends on the situation. And also, just as to follow up on that, and I think it's a really interesting question you ask. It's not a question that gets asked often, at least not that I've heard. But it's a really interesting question, is that when you provide and deliver that humor, you really need to concentrate on the parties to see how they react, the active listening skill set, because what you don't want to do is do something too much, because if you then add more humor into the process, it may then distract from where you need to be in terms of the fluidity or the rhythm, what I like to call like a musical. You're having a rhythm go on from the beginning of the mediation process until its end, whether it's a completed, successful mediation. We can go on for hours in what we define that to be. Obviously, every mediator wants a successful mediation to be defined as a settlement agreement, but that doesn't necessarily mean it has to be. But yes, so I think that's a really great comment that you've made, and I think it's a really important facet.
And I would add to what David just referenced, humor has to be used very thoughtfully, because if the humor is misunderstood and it seems to demean the passion with which people speak, and as a result they feel you're really insulting them by the not taking seriously the pain that they feel, then of course it can really backfire. So one has to use it very, very carefully. But it's a great icebreaker in terms of moving things forward.
This question was from here because yesterday night I was looking at videos about mediation. This process, and there was some topics about the geographical difference between people who live in the north side and people who live in the central side.
That's right.
Have a very
Different perception of what humor is.
how it works.
Right.
Which side is better and what you must choose.
That's right. And you've got to exercise that judgment carefully. You really do. My technique, and I'll share something with you just to give you a practical, what I call mind-setting approach. At the beginning, now I'm not a defense lawyer, okay? I'm talking about the mediations that I do, where I'm chosen to act as the neutral. Not for my clients, this is for other people where they've asked me to be a mediator. I like to have what I call a sober mind setting. And at the very beginning of almost every mediation that I do, I ask the parties a few questions. Or actually, I really say it more as a statement. It's a question, but it's really a statement. Are you prepared? Do you understand that you are not going to convince the other side they're wrong and you're right? I ask each of the parties. And I emphasize you are not here to convince the other side that they're wrong and you're right. And if you are, you're in the wrong proceeding. Because that's not what's going to happen here. What's going to happen here is we're going to go beyond what's right and wrong. And we're going to focus on how to fix the problem. And as I like to say it, what we want you to do is, in essence, agree to disagree. This is kind of my own approach in mediation. I want the two of you at the beginning of the process to agree. You're going to disagree about who's right or wrong, and let's focus on moving forward to reach a resolution. And sometimes I'll spend an hour on this when I really don't think I've got the right buy-in from the parties. I don't have their commitment to this, so they understand the process is. Now, we all agree. You allow emotions, you allow pain, you allow anger, you try and do it in a constructive way. Usually you do that through private caucusing. You don't do that together, which just raises all the anger even worse. Sometimes you do have it together, particularly family disputes. It may be important if they're able to communicate their anger in a constructive way so that people understand their position. All of those are the judgment calls that you make in terms of how you are going to mediate the dispute or represent your clients in the mediation. So there are all these different techniques that make an enormous difference on how successful you can be in the process. One other question, I'll come back to you. Yes, sir, in the back.
How do the sides choose a mediator?
Ah,
How do they agree together?
okay. How do you decide to choose a mediator? I can kick off on that one, or would you want me to start it?
Yeah.
So you're asking in the United States, for example, how do they do it? In the United States, there are a number of private mediation organizations. One, some of you may have heard, is called JAMS, Judicial Arbitration Mediation Services. It's the largest in the world, happens to be in California. These people all have histories of their experience. They have clients that they've worked with, and they give, with the permission of the clients, they give the names out. So in my case, where I'm looking for a mediator, I will call lawyers that have dealt with that mediator. I'll look at the CV, the biography of the mediator. I'll find out what their knowledge is of the subject matter, if that's important, or generally that's not the most important thing. I'll look at their experience. I'll call the lawyers if I'm representing a client as a defendant. Did you get a fair hearing? Was the person tenacious in getting a settlement? All the qualities I'm looking for. And then I'll narrow it down. I discuss with my client where it's a close call on which is the best one. Of course, I look at their certifications and, that they're properly selected. So it's a very careful process.
One quick question related to this. Do you ask your friends or your colleagues, are you calling them, for example, there is a mediator A and there is a mediator B, which one is better?
Yes.
Which one would you recommend?
Absolutely.
Do you do that?
Yes, I will call my colleagues either in my firm or other firms, or if I see it's a case that a colleague handles, I'll call them on the phone, and I rely, if I trust that colleague, I rely very heavily on their experience. That's really important. And sometimes I'm looking for a different type of mediator. Now, I'm going to raise something that's very controversial before I turn it over to my colleagues. We have something that we call evaluative mediation. Have any of you heard of that concept, evaluative mediation versus facilitated mediation? Okay, as you say, of course. I never take that for granted. All right? I like evaluative mediation. Some countries and cultures, they don't believe you should do it at all. I'm that kind of a mediator, and when I mediate a case, I usually ask the parties if they are open to that because I really feel it's very helpful. With clients that I bring into mediation, where somebody else is the mediator, I want to know what's their style. And we're able in the United States to call a mediator on the phone and say, tell me what your style is. What kind of business disputes? What kind of marital disputes? What kind of landlord-tenant disputes? And will you be evaluative, and in what way, to find out what their style is? So that's part of the criteria you look for. There are some mediators in the United States, I don't know how they do it, but they are very successful. And they are what you call facilitative. They basically facilitate exchange of proposals. They nurture the parties in kind of a motherly and fatherly way towards a resolution. I tend to be, when I do a mediation, I'll take the attorney aside privately and say, what are you talking about? You're relying on case A. Case A doesn't stand for the proposition that you're talking about. And your facts, your evidence here is very weak. Your facts are strong. And that case, the other case, but you've got some exposure. And I'll do that privately with one of the sides to sober them up about what I feel about the case. And if they respect you as a mediator, in my case, I've been very fortunate. I've never lost a jury or bench trial in these 50 years. I've been very lucky. They listen. And that's part of the credentialing. What kind of a lawyer are you looking for, or judge? Or it can be a non-lawyer that's an expertise in the area that you're talking about. In fact, it could be a psychologist or a family counselor that's taught mediation skills in family disputes. All of those are the considerations you take into account, and that's why you are paid as a lawyer well to do this for a client, because that is an art in itself. You pick the wrong mediator, you're wasting your client's time. Very, very important. Jennifer.
Also, we have, in New Jersey, we have court-approved mediators. I think it's going to be similar to your unified registry of mediators that will eventually seem to happen. So these mediators have been approved by the court, have had certain training, certain number of cases, certain number of years of experience, have been mentored, have been coached. So they are on what we call the roster of court-approved mediators. I happen to be on that. I'm one of the few who do it for both commercial cases but also family cases. So, often people go to those lists of court-approved who already have been vetted and approved by the court system. When I'm referring to people, sometimes you pick from that list, and sometimes you pick from private mediators who aren't on the list or don't want to be on the list. So you also ask your colleagues, who do you think is good, but you also want to look for a good match. Who do you think, temperament-wise, personality-wise, maybe expertise-wise, would be a good fit for the kind of case that's involved and the kind of personalities and character of the clients? Do they want someone who's really strong and forceful, who's going to push in a different way? Do they want someone who might be a little bit more laid back, more patient? So you look for all of those techniques. But in order to become a mediator who people pick, number one, you get as many credentials as you could get. You try to get on those lists because that's another source of referrals. And it's networking. And part of what David had said earlier about going to these conferences and going to competitions, you start building networks of colleagues, both here in Georgia and abroad. You eventually get more and more referrals, and you get involved in the system.
David, anything you want to add? Or?
Sure. Just two things, but I see two questions. So I'll give you two things to take away from this. So mediation continues to develop. And in this specific question, we think about mediation ethics. So one of the concerns that we have in the United States is that mediators trying to please too many of their lawyer friends because they want the cases, or they need to settle cases in order to get the next mediation. So one of the things you need to sort of just give thought to is some of the ethical requirements that you need or should possess as a mediator so that you don't find yourself in those situations, because ultimately clients are smart enough that they will realize, or they will figure out that, isn't fair and balanced. So you do want to address that. The other is training. Training is really important. In order for mediation to continue to grow, and not only here, but around the world, training is number one. Training, training, training. Because the worst thing that we can have to this growing field is a tarnishing of the mediation practice by poor mediators, and then the mediation going away and becoming something that is read in the textbooks as an old model but not used anymore. And everything goes back to really an adversarial position of litigation or arbitration.
And what about the wages of the mediator?
What's the question?
Wages.
Wages. You mean for the mediator?
How much per year?
Salary,
In terms of as a mediator.
Yes.
All right, I'm going to tell you something. You got your seatbelts on? Okay? You want to guess what the top mediators in the United States make per day? $5,000 a day? $10,000 a day? $15,000 a day? $20,000 a day? Do you know what the cost of a mediator is to the size of some of these disputes? It's irrelevant. The best mediators that I know of in the United States range anywhere between $10,000 to $20,000 a day.
A day?
A day! okay? That's quite a bit of money, okay? I'll tell you a secret, a big secret, that's a big secret. I charge $6,500 a day for most of my mediations. That's a lot of money even in the United States, much less here. So when they choose me to be a mediator, they better be serious because it's a lot of money.
However,
What however?
excuse me, ladies. It is a very, very small handful of mediators who make that kind of money. It's very rare. Most mediators, a lot of times they make the same rate per hour as an attorney makes. Sometimes they charge more for mediation because they're dealing with multiple parties. So their hourly rate is a bit higher, and the parties share it, because usually the best way is for the parties to share it. They both have an equal stake in it. They're both involved, and it also helps keep neutrality. So one party's not paying you, so you're not going to take their side, just like you mentioned ethics. And even if you have colleagues who are big lawyers and big law firms, you're not going to favor their client over someone else. You must always maintain your neutrality. You must be fair, because once a party thinks that you are not neutral, you're over as a mediator. So you always have to have that ethical duty to the neutrality. You do not take sides. Now, I tell people, I don't take sides. I don't know you. I'm not going to pick one side over the other. However, I may feel a certain position may be more reasonable, or it may be something that will help move the case in a certain way, but not because I favor them, but because maybe this seems to be a better direction, having a little bit more evaluative concept, but always neutrality. And they don't make that kind of money. That's really very rare.
Okay.
Sorry,
Don't be sorry at all.
I wish I did.
Because I don't want to give a
No,
misimpression,
I
and I think that's an
Yeah.
important, very important
Yeah.
balance that Jennifer brings to it. Because for family law matters, there are many not high profile, but very important matters on an individual basis for which hourly rates are charged that are much more reasonable than the kinds of money here. But I want you to understand that the very best out there, and the very good ones, even not the very best, but very good, can charge substantial amounts of money and make such a good living that judges are leaving the bench as judges where they are not well paid, and they have become a category of some of the most well compensated mediators. If they learn in mediation, they don't act like judges, they have to be mediators. And for some judges, they never get the robe off, you know? They're always judgmental. They're the worst, and they get wiped out right away because they don't get people that, once that's it, they're out. But the judges that learn the mediation skill, those are the ones, excuse me?
Prosecutors as well.
And prosecutors as well too, exactly. Yes, you had a question.
Okay, just building up on the income level.
Yes.
Let's think about demand, meaning that you probably experienced and like seeing in front of your eyes how society perceive mediation as a beneficial tool.
Right.
So in Georgia, it's almost on the path of progress. So we're going to see in front of our eyes as a future leaders or governors. So how that build-up progressed in the U.S. and how much, I'm not speaking about how much time it takes, it's just how it changed over time. What walls it need to face and what we might expect.
Good question, very good question. Again, I'm happy to kick it off if any of you care to.
I don't mind answering.
Go ahead,
this question.
sure.
It's a misnomer. I mean, mediation in the United States has been used for a number of years. But mediation is one of those unique, I have found, it's one of those unique disciplines that is always evolving because it's very tied to society and cultural norms of the time and era we live in. So if you go back 10, 15, even 20 years ago, so I graduated law school 20 years ago, right? There was an ADR class, I think, but it wasn't something I would have taken. I was interested in litigation and court, and that's where we were. Today, every school, you can't go through a law school without knowing about an ADR program and international competition. So what's happening is, even in the United States, we are going through a new evolution, and that's why I make the comment about the business community Because where mediation really began was in the family space and certainly evolved in the labor space. But in the business world, it is still, unless you're at like doing multinational companies where they know they're not gonna kill their subcontractor deals with their relationships they've had for 30 years. So they're gonna have to figure out ways to resolve their disputes. But go down the elevator, you know, from the penthouse floor to the 5th floor, the 6th floor, the meat and potatoes of companies, and you will find that all of a sudden, once they're aware, once they understand the benefits of mediation, they say, wait, it's time effective, it's cost effective, and I may be able to maintain my relationship with someone that is important to me outside of the fact that we have this current dispute right now. So I know it's not the 1 + 1 = 2 question, but again, you're going to be a lawyer, so there is no 1 + 1 = 2. But it is a field that even in the United States continues to evolve and grow as society changes and adapts.
And just adding to that, part of it is also in terms of growing mediation here. It is education because there are law schools in many countries that have no mediation programs. We were just in Sofia, Bulgaria, and one of the excellent schools had it, and the oldest university, the Law Factory, has no mediation course, has no alternative dispute resolution course. So we also say that it comes from, it could start at the top and trickle down, and it could also start at the bottom. So in other words, you want to engage the court, the judiciary, the judges, the business schools, law schools, but also you want the people to know about it. So for example, when someone files a complaint in the court, when they get those papers in the mail or it's delivered to them, there's also going to be information about mediation as an alternative. When people go to the courts, there'll be brochures and pamphlets about mediation as a possibility. There are sometimes they role plays, excuse me, on TV screens in the courthouses while people are waiting to see it. So it's many different levels and facets of making this information available to the public and also to educate the judges about the process.
In one interesting situation, in India, one of the states, I don't know if any of you know much of the geography of India, but there's a state in southwestern India called Kerala, and they actually started you know what a soap opera is? Have you heard that expression, soap opera? Yeah. Which is, you know, this drama every day, people are crying all the time, and it's usually during the day, and there's some great crisis from one day to the next. And they made a soap opera out of a mediation. And every day they build this drama about the case that came before a mediator, and of course the public was very interested in the outcome of the case, and I thought, well, it was an interesting way to educate the public. It ended up being one of the highest rated TV programs that people really got into, and that was one of the ways they educated the public about you know, what mediation was all about. So there are many different ways to do it, and of course publicity is really important, public speaking, writing, newspaper articles, and the like. And that's part of what you're going to be engaged in. Yes, ma'am.
First of all, thank you for your interesting speech. It's really very useful for us nowadays. I have two questions, if it doesn't take too much time. First of all, as you know, in the United States, several states sometimes require a special license for mediators, so practically everyone can be a mediator. But don't you think that the government must take a responsibility for the person, for his or her qualifications, who will help them later, different to confronted parties in the court or maybe out of court? And another question, what do you think, what are the main challenges for lawyers who represent different people in the court, for them about mediation process?
Good, both are good questions. And by the way, just so you know, we'll take one more question after this, and then we'll let you go, and we'll stay for any questions you might want to ask us. So on the first question, government involvement as far as certification and review of mediators, kind of how does that operate into your systems? Would either of you like to comment on that?
I mean, I can take a shot at it. I think it's, again, a really, really excellent question, especially coming from the perspective of a country like Georgia, which is beginning its mediation process. So, you know, the United States evolved on its own with mediation developed out, we don't have necessarily a license. Everything would be governed by its own individual state anyway. There are mandatory certification programs you have to go through for hours of training if you want to be on these mediation panels that are on the mandatory mediation panels, whether in the state courts or in the federal courts. But you could just hang your license out there and call yourself Mr. Mediator in New Jersey. I mean, there's nothing that precludes you from doing that. I would say that I'm torn on that in my own country at this point. I mean, I think that there are some concerns, and I raised them before, about training, and I think it can hurt the overall integrity of what the program and the discipline is about, especially when you have a lot of others coming, even in the United States, from the direction saying, no, we want to see arbitration, we want to see litigation, so see, aha, all these mediators are really, messing up the process. Here, and in other countries around the world that are first now developing their mediation training programs, I think it probably bodes well to have some sort of oversight in somewhere, whether it's the government to a relationship like your bar associations and mediation councils, something that allows so that this can take shape in such a way that it creates some integrity to the process.
So one of the things I want to mention, and then I'll take one more question and then we'll conclude this session. In the United States, those lawyers that became part of that program where we volunteer our time, that program continues today. And they now have a panel of 375 active volunteer, which I still continue, volunteer mediators who serve the court for no charge. There is a way to get compensation, but basically they volunteer their time. The waiting list of lawyers that want to get on that panel is almost 2,000 lawyers in California. I mean, that's how popular it's become. Why do they do it? They do it out of the heart because they believe in the process of helping the courts, which is good. The selfish interest they have professionally, it raises their integrity in the field. And you can also bet your last dollar that when they go before a judge to argue one of their cases, they're going to get every bit of respect from that judge. No special favors, but they will be regarded highly enough by the judges they have to appear, that they will be given their time, their fair shake, when they have to represent their clients, which is perfectly legitimate and appropriate. So there are many benefits that come from this process. And I think the question also is, what are the challenges with respect to lawyers? I'll give you the short answer. The lawyers don't understand that they are not there to win the case. The lawyers come in, and I did this in my first mediation. I came in and I was representing a client, and I felt the plaintiff in that case was absolutely lying about what happened to them, and I lambasted that client at the opening statement, and the mediator looked at me, and I didn't understand what I was doing wrong. And he said, that's one hell of a way to open up a mediation counselor, and he was right. Because I so humiliated the other side that it took us 15 steps back. And that's why in my mediations, I open it with an explanation of what we're going to do, so the expectations are set. And the emotion can come out in private caucus, but you don't do that in an opening session with everybody else. So understanding as a lawyer how you advocate with a focus to solving the problem and not beating up the other side. That is one of the most common errors.
And the other thing I like to do is I like the clients to speak and not their attorneys to speak all the time.
Yeah.
I often have the clients sit next to me and not just the attorneys, and I want the parties to engage and to say their story, because sometimes the other side has never really heard what happened. They only heard what their attorney said, the other attorney said, that their client said. It's like there was a child we played as children where you start at one end and you whisper something and he'd whisper, and by the time it got to the end, it was nothing like what was said. So it's a chance for the parties to tell their story and to speak and to say what happened to them.
And that's why we talked among ourselves the other day about this, and David pointed out, most of us spend the first 45 minutes to an hour just getting to know the parties in the mediation. If I have a business dispute and I've got a company, I'll ask them, I'll start off my private caucus and I'll be talking about how is your business and what's happening in the business community. oh, you do have children in the business. How old are your children? You want to build that rapport and trust so they can they see you as someone that really cares about them and is trying to reach a good resolution.
And just following up on that, I mean, I've been in a divorce situation where I've asked the parties how they met.
Yeah.
I've seen pictures of their children. So it changes their mindset that now they're thinking, oh, we loved each other once, or we love these children, because I always say, the children are the most important thing, because your children, you could fight each other all you want, and you'll be okay, you're grown-ups, but your children will be destroyed in the process.
And what Vic and Jennifer are doing right now is giving you an actual technique. It's called building trust with the mediator, as well as what we call building confidence in the mediator to conduct the process, two different terms. But right there, you just saw a technique.
Okay, one more question, if there is one, and then we're going to break. Yes, ma'am.
I wonder, is it very hard for a lawyer to take mediation cases and trial cases at the same time?
At the same time?
Yes, at the same time, because we have to, as you have already mentioned, as a lawyer, we have to learn that while mediating process, we don't have to fight to win.
Right.
We just have to talk and discuss everything. And on the trial, it happens totally different.
You're out to win.
Yes.
Okay, I'll take a first shot at that one if you don't mind, because I did this for many, many years. The question was, if you couldn't hear in the back, is it hard or possible for a lawyer to be trying cases and also mediating cases? Now, do you mean act as a mediator or be a representative for the client in mediation?
Represent.
Okay, to represent a client in mediation. And the answer is no, it's not hard at all. You just need to develop the skill of understanding how you're using your advocacy. In the case of a trial, you're using it to prove to a judge, or in our system, a jury, why the evidence shows your client's right and why the law is in your favor, okay? And you're aggressively, if you will, attacking the other side to win. So it's a very assertive, very competitive, intense style. But what are you doing in a mediation? You are using that same talent to a different end, which is use the best arguments to show why the resolution that you want and that will work for you is what the mediator works to get from the other side. It's more emotionally enjoyable because you don't have to attack the other side, but you've got to use all the same talents of analysis and what facts are good and what facts are not good. And you've got to convince your client when it's time for them to compromise, when they don't want to give anything, so that you can reach a resolution to move forward. All of those are very related skills. Some lawyers can never make that bridge. There are some trial lawyers that never get out of it. They argue with their spouses, they argue with their children, they argue with their next door neighbor, and they argue with everybody in court. There are other lawyers that have that kind of flexibility, and it's a wonderful new toolbox and a wonderful way to expand your practice. But you've got to understand what the difference is. So, you've been very patient. I know there were some other hands that were going up that we didn't get to. We're happy to stay a little while to answer any of your questions, but I don't want to keep everybody here. I want to close by, once again, on behalf of David and Jennifer, to thank you for the opportunity to come here and speak. I want to tell you, you've got great guys like Georgi here that are teaching and mentoring. I think one of, if I'm not mistaken, one of your students is somebody that we work very closely with over the years. Alex has been just a terrific resource to us, and he has had the benefit of what Georgi has taught and developed here. And you are a further, a future legacy to what is going to be built here in Georgia. And I hope we've conveyed with you some of the ideas and the vision of what will be valuable for you, not only as professionals, as earners of good fees, but also doing much to build the economy and the legal system here in Georgia. So with that, thank you so much for your time, and we're free to answer any questions.